Appeal is dismissed.
My lord, with the consent of the other side, my lord, I beg to mention item numbers 38 to 44, my lord. My lord, in these cases, I was required to file in my lord, affidavit in opposition, my lord. For the personal difficulties, I could not bring it on record. She's here. 38 to 44. This is a series, my lord. Taken up after 4 weeks, my lord.
All right. On the prayer of learned counsel for petitioner.
Petitioner. No, my lord, I am for the respondent.
I'm for the petition.
He's for the
The respondent, and with the consent of learned counsel for the petitioner, lays the matter again on.
obligement.
Please, Your Lordship.
Yes.
I beg to mention item number 16. Have we taken out another basis?
Huh?
In this case, Lordship, conducting by learned senior counsel, Mr. Ashish Sharma, Lordship.
Item
1/6, Lordship. Order
1/6, list the matter before another bench without me. On, give it date.
My lord, in regard to item 2, my lord, I have taken consent of my learned friend. Sorry, my lord, item 6. 6 or 5?
6, I suppose.
Yes.
My lord, a little bit of accommodation, my lord, we could not make some correction to be made. Earlier occasion also I took time. I am very sorry for that.
Learned counsel petitioner, and with the consent of the counsel for the respondent, list the matter again on. Do you want?
Convenient to my learned friend.
Convenient to my senior, my lord.
After 3 weeks, my lord, any date.
Can it be any date after 6th April? Before view vacation and after 10th April?
Obliged.
May it please, Your Lordship. Your Lordship, I beg to, with the consent of the other side, I beg to mention item number 4, Lordship. We have already informed the other side. I pray for adjournment for today, Lordship.
Date.
After verification, any date may be. After 22 April, 25th, after 25 April. Interim order is there, Lordship.
Interim order passed earlier to continue. Next date of list.
Much obliged.
Please, Your Lordship, I beg to mention item number 12. Matter may adjourn for today, Lordship, as the conducting counsel is out of station. And the additional affidavit will also filed. Okay. Item number 12. Matter may list at 20 March, Lordship. List at 20 March.
Number 2.
Your Lordship. The second anticipated bail application, previously by order dated 8/1/2026, Your Lordship was pleased to reject the AB application. Your Lordship would find at page 18. We fair Your Lordships, wide order dated 6/3/26 and 9/3/26, Your Lordship was pleased to reject the second anticipated bail application filed by the other petitioners.
For that case,
Your Lordship,
all right, same order.
obliged.
Yes, they have earlier petitioner stated that charge sheet has been submitted, Lord. I have no information on that. Any other development?
Call it up later.
This one, item number 3.
Sorry, Miller, one item, Miller, in this case, Miller, charge sheet has been submitted, I am told.
For that one.
11, so that I'll go.
Is here then?
Lordship, he will appear in the lower court, Lordship. He's stating that he will appear before the Lord.
Our learned counsel for the petitioner and learned additional PP, it is submitted on behalf of the petitioner that charge sheet has already been submitted and that the petitioner will appear before the learned court below.
Item 11.
11.
11.
Item 11.
Yes,
I'll appear in the court below, Miller, and pray for regular bail there.
and apply for regular bail. Hence, this petition stands closed accordingly.
What's matter may be taken up after some time as the conducting counsel is in quote 7.
May I please, Your Lordship? Your Lordship, this matter has come up for a third time, Your Lordship. On the last two occasions, there was a different engaged counsel and there was none appearance. So on 5/5/2025, Your Lordship, I had filed wakalatnama. Your Lordship, this is a miscellaneous first appeal challenging the very judgment and order dated 12/12/2023 passed by the Learned Railway Claims Tribunal, Your Lordship, on the accidental fall of the late husband of the appellant, Your Lordship. So, Your Lordship, I pray that this matter may be admitted and the trial court's record may be called for, Your Lordship.
Yes. Heard Mr.
D. S. Deka, Your Lordship.
Counsel for the appellant and Mr.
Yes, that's right.
The counsel appearing for the railways. This appeal is directed against the order so and so passed by Learned Railway Claims Tribunal. The appeal is admitted for hearing. Call for the TCR. Is the matter again on.
Much obliged, Your Lordship.
Obliged.
Lordship, this is a MFA filed under section 30 of the Workmen's Compensation Act, Lordship. The substantial question of law I have mentioned at page 7, Lordship. Lordship, there was no employee-employee relationship. And maybe it's the substantial question of law 2, maybe of fact, Lordship, that might.
Page?
Page 7 of my memo of appeal. And the person died of electrocution, so section 3 won't be coming.
So, what was the finding with regard to the employee-employer relationship?
Lordship. Lordship, issue number 4 at page 15, the court has said.
And that is whether he is to get whether he is employee or not.
That court.
Employer-employee relationship, that is the question, first question you have framed.
Yes, Lordship.
So where is the discussion on that?
That discussion, Lordship, issue number 4, page 15, court has just said from the above discussion of the issues, it is crystal clear that the deceased employee died due to deceased employee. The court is coming to this deceased employee of electrocution.
So,
And
did you raise that issue in your WS? That there was no employer-employee relationship? Unless you do that, how can you bring it in now?
no, Lordship, that
It is a
they
matter
have
of
to-
evidence.
They have to prove it, that it is for the workmen. If they want to get, they have to prove that.
If you don't deny, why should they prove? It's taken as proved if you do not deny it.
I'm just going through the written statement. Lordship, it was denied that no premium for handyman was paid at para 5 of our written statement. Then Lordship, then also the liability of OP2, if any, always will be subject to terms and condition of liabilities as are detailed and specified in the policy of insurance, Lordship.
I am not on the copy paste part.
Yes, Lordship. No, Lordship, that is not copy paste when it is clearly mentioned with highlighted, no premium for handyman has been paid by the insured, and however, the answer denied the policy.
That means you accepted he's a handyman.
No, Lordship. That we are not accepting, Lordship. We are saying that no premium was paid for him. We are taking all the defenses. Electrocution. Then again, Lordship, at para 11, it is mentioned that he died of electrocution. The electrocution won't be covered by the policy, Lordship.
That is not the first substantial question. We are going question wise.
Acha. For that, Lordship, that is what is mentioned, Lordship. That question in the written statement, that is what is mentioned. Lordship.
What is mentioned?
That no premium was paid for him. And also para 2, that the claim petition not as it is, it's present from under section 4 of employees compensation, and further the claim petition very vexatious, incomplete that way. They have to prove the employer-employee relationship, Lordship. Moreover, I haven't filed the IA also, Lordship, in this case. In fact, I was supposed to take time because, Lordship, the stay petition is not filed by us. Inadvertently. এখন ফাইল করা হয় নাই বাকি রয়ে গেছে হ্যাঁ ও সেইখন আই আছে আই এখন ফাইল কৰিব ৰৈ গৈছে
Please try to understand.
Yes,
We are not required to admit this by taking the questions framed by you at its face value. We have to determine at the initial stage itself whether such a question arises. That is why I am putting that question to you.
That is correct, Lordship. I understand that, Lordship. But I am bound by whatever is there on record. I cannot submit something beyond the record, Lordship. But the thing is that they have to prove that he was the employee. That employer, McKinnon McKenzie is very clear on that, Lordship. That judgment. They have to stand on their own footing, not by the defendants or opposite parties' claim or rejection, Lordship.
It is dealt with in issue number 2.
Yes. From the exhibit 1 and 4. Listen. Was involved in that. Thus the relationship. Lordship, truck was not involved. He died of electrocution. And this vehicle was taken on insurance.
Truck got electrocuted. The learned court held that it was proved, but it's a question whether it was properly proved or not. That is a question of fact, actually.
Will be law if section 3 is involved, Lordship, if the employer-employee relation is in section 3, if they get compensation only if the employer here did not appear in the court. He did not say that he was employed.
Those are matters of evidence. We are on a substantial question of law. In fact, it was the case that there was no such relationship proved. And yet the tribunal or whatever authority proceeded to award compensation. Is it permissible under law? But when the authority below has held that the relationship is proved, does it remain a substantial question of law?
Maybe my English is not correct, Lordship may formulate the.
It's not a matter of your English. We are not on your English. We never do that.
No, not. Okay.
Where is your WS?
We have not annexed, Lordship.
You're supposed to file some IA also.
Stay petition, yes, Lordship, inadvertently we could not file stay petition.
All right, then you filed the stay petition along with your written statement also.
Fine.
We'll examine that question.
Fine. Admit.
It is submitted
I didn't
by
know.
learned counsel for the
I didn't know for it.
appellant that appellant wants to file an IA for stay of the impugned judgment, which was inadvertently not filed along with the present appeal. Hence, release the matter after 2 weeks.
One copy, my lord. One copy will be served, my lord.
দি দিম আজি এডমিট হলে কৰিলো এটেন আদাৰৱাইজ দি দিম এতিয়া দি দিম চৰকাৰী কাগজ এইটোৱে ফোন নম্বৰ নহয় জানো
হয়
অবলাইজ
For the respondents, for respondents.
There was page number 128, para 3, Your Lordship.
Your respondent number?
For all the
All.
Yes.
Name is shown.
There is a post. Name is not reflected in the cause list.
No, petitioner. Timing to something. Who's what time? Petitioner.
Fixed for a next day.
Huh?
Can we fix for?
Fix? I don't know. Huh? Timing থাকো বিষয় না।
Please, my lord. The appellant is the insurance company, Your Lordship. This is an appeal against the award of Employees Commissioner Noga, Your Lordship. And here we have challenged, Lordship, the disability certificate, which was issued by a private doctor, and that was issued after 8 years of the injury, Lordship. This is our main ground of appeal, Lordship, here. And Lordship will find that certificate in the form of injury report, that is page 26 and Annexure 4. It has been issued by a private doctor in a private chamber. It's not accordance in law, Lordship. A due procedure was not followed. It's not by medical board, Lordship. And that too after 8 years of the injury, Lordship. And there is some guidelines also, there is decision also, Lordship. And the private disability certificate issued by a private doctor cannot be considered, Lordship. In a recent decision also, Honorable High Court of Himachal Pradesh has issued certain guidelines to the Additional Chief Secretary of Home Department, Lordship, regarding issuance of this type of certificates, Lordship, by private doctors. There are specific guidelines by the Ministry of Social Justice and Empowerment, Lordship, under the Disability Act. I have the guidelines and the decisions also, Lordship. Grounds are written specifically in pair number 12, 13, Lordship. That is, we are challenging the exhibit 21. That was the injury report, and that was considered as a disciplinary certificate by the Learned Employees Commission, Lordship. 40% loss of income was calculated on the basis of that disciplinary certificate. Whether it was a permanent disability or a permanent partial disability, that was not discussed, Lordship.
And the concerned doctor was not an orthopedic surgeon also. He was a general practitioner, the doctor who issued the disability certificate. The locomotor disability laws. হয় বাইদেউ আপুনি
My lord.
Four. So where is the substantial question of law?
The substantial question involves that whether the land commissioner was right in accepting that disability certificate and accordingly.
Where are you reading from?
Lordship.
Where are you reading from?
Lordship, yeah, I have in my grounds, Lordship, I have.
Page?
This number 9, where number 12, 13. Lordship, then I have pair number 10, Lordship. And I have stated in pair number 16 that it involves a substantial question of law to present appeals which is to be decided by this honorable court. Pair number 15 also. No, size.
What is the disability said to have been suffered by him?
Here, Lordship, permanent in nature, Lordship, but physical disability is permanent in nature, but it doesn't say specifically, or is it total permanent or partial permanent, Lordship?
Which part of the body?
In the opinion portion, page number 26, and excerpt 4, Lordship. In the opinion portion below that, in the bottom, physical disability, last sentence, first last sentence also. It's not stated whether it's a permanent total disablement or partial disablement. Only permanent in nature it is misstated. Also, earning capacity has been stated as 40%. Here, whether it is a permanent total disablement or permanent partial disablement. Permanent partial disablement, Lordship, it will go in the part 2 of schedule 1. that will be counted on the injury disablement on the particular limb, Lordship. But here this 40% has been taken. That too by a private doctor, you see, Lordship, as only an injury report. An injury report only, and by general practitioner, Lordship. Lordship, we should provide the guidelines also. Indeed, was. I have marked the guidelines also of 2001 and 2008, but a board should be constituted, how the board should be constituted, and what will be the format of the discipline certificate, and what particulars should be there in the certificate. In case number 3, it's a format, performer format also. I've marked the relevant portions. Yeah, we'll see, Lordship, in page number 3. Yes, there is a standard format of the certificate, and here it is said that this that there should be, there is a note. This condition is progressive, non-progressive, likely to be improved, likely to improve. Reassessment is not recommended. It's recommended. This should be there, and after how many months it should be a reassessment, and there is signature of doctor should be there. 3 doctors should be there with seal, Lordship, and there should be thumb impression of the patient, Lordship, and there should be a hospital seal, Lordship, and recent photograph of the patient, Lordship. And here in this case, this has been issued after 8 years of the disability injury, Lordship. And it was been by one Dr. Dhirendranath Hazarika, who is a general practitioner, retired Leforsi. He is not an orthopedic surgeon. He has a private chamber, Lordship, at Nagaon.
We'd had learned counsel for the appellant. Counsel, you are appearing for
My lord.
number 2. Who is one?
Claimant, Lordship.
The citizen appeal against the under section 30 of the Police Compensation Act 1923 against the judgment and order dated 19/1/2023 in case number NECWC 107 of 2009, passed by the for Employees Compensation Labor Commissioner. Upon perusal of the memo of appeal and hearing, learned counsel, the appeal is admitted on the following substantial question of law: whether the learned raise compensation and affected disregard of the law by basing his findings regarding disability and loss of earning capacity of the claimant on the basis of report issued by a private doctor without there being any report from a medical board duly constituted by the central or state government. Full stop. Issue notice. The respondent number 1. Appellant to take steps by speed post with AD within 3 days. In the meantime, call for the records. It would be open for the parties to urge any further substantial question of law at the time of hearing. Yeah, IA is there.
No, Lordship.
No stay prayer is there.
Lordship, one I was there. That was delay, Lordship. Confirmation of delay. 10 is not there. That's in,
Stay is not required.
not required. But we haven't filed. Stay here. Otherwise, if complaint would have appeared, we could have referred this case for lookup, Lordship. It's not a very big amount. It's only 1,98,000, 91,000. Solman has not appeared till.
This again on.
Obliged, Lordship.
Can your lordship take the matter tomorrow by reflecting my name? My name has not been shown. Is the matter again on tomorrow, 12th, tomorrow, showing the name of Mr. C.C. Doctor. Respondents column. Appellants column. Obliged.
Please, your lordship. In this case, the injured workman was an employee in a cement factory, lordship. Unlike most of the cases which occur under motor vehicles policy, this was a purely contractual policy without any statutory obligation on the insured, lordship. The employer had insured his employees for particular sum insured for all various different sum insured. Lordship, in this case, the claimant had filed a compensation under the before the commissioner, lordship. And the commissioner has accordingly passed an award against the order against the insurance company, despite a petition for striking out the name of the insurer by the insurance company on the ground that this matter, the commissioner does not have the jurisdiction to entertain this matter. Lordship, in this case, because lordship, I understand the obligation, employer has a statutory liability towards the employees to compensate them for any injury or death. But here the dispute is between the insurer and the insured employer. How much they will pay under the policy. That is a statutory liability which is to be determined by the commissioner. Here is a case, we are liable only under the policy, it's a commercial company. Lordship, this matter has been decided by the Supreme Court in one of the cases, Lordship, if I may. Also, there are other substantial question of not just this. The commissioner has also assessed the injury without taking the aid of a doctor. And as per law, section 41C, he has to take the assistance of a doctor to determine the loss of earning capacity. Lordship, pair number 13, Lordship. If I may come directly to the point, It's a similar case. It's not a motor worker, but a employee of a construction firm. Notably, liability of the insurance company does not fall under the Act, and the same is governed only by the terms of the contract. When parties have agreed upon the terms of the insurance contract, the court cannot interpret the clauses in the contract by adverting to equity principles. It is because in commercial transactions, the question of lack of bargaining power does not arise. This was the view taken by a 3 judge bench of this court in so-and-so lordship. So it is similar. It's a similar situation. Now he was not an motor vehicle worker, in which automatically the MV Act will apply, and by virtue of the MV Act, the WC Act will apply. There is also another substantive question of law, lordship. The case of injury, and Land Commissioner has decided the case without reference any certificate from a doctor, without examination of it. I have framed the lordship substantive question of in page number 8 of the memo appeal, A to C.
First substantial question is whether in the given facts where the dispute was between employer and workman, does the commissioner have jurisdiction to hold the appellant liable?
Appellant as the insurer.
Hmm.
Under a policy of insurance between the appellant and the employer. Purpose of this is to reimburse whatever the tribunal commissioner decides, lordship determines. To that extent, to what extent has been that insurance has been taken, the insurance company reimburse the after he satisfied that. It's basically policy for reimbursement of any liability that he occurs towards the yield. If he has insured adequately, he'll get 100%. If he is indicate wanted to save premium insures for lower amount.
No, before that, what I'm trying to understand is insurance policy is between you and the employer.
Yes, Lord.
And
Also, he has the option of choosing the sum insured.
your question is, does the commissioner have jurisdiction to hold whether you are liable
Yes, Lord.
to pay compensation?
Yes, Lord.
So if the insurance policy is between you and the employer, that is the precise question where the commissioner has to decide whether you are liable to pay insurance or not. What other question he has to decide after deciding that he has?
He has to determine how much the employer is liable for the compensation to the workman. And after that, usually it happens this way, lordship. After that,
Don't talk about usual things.
Yes, sir.
We are on the substantial question of law.
Yes, sir.
I want to know what you practice out there. Answer the question from the court.
Yes, lordship.
Policy is between you and the employer.
Yes, lordship.
So why would not the commissioner have jurisdiction to decide whether you are liable to pay?
Because between me and the employer, lordship, it would governed by the terms of the contract.
So we'll decide that.
Because if the employer is not satisfied, he will again file a E against me. If the employer, he thinks I have given less, then I have to pay under the contract. This is a contractual obligation, lordship. And that is a statutory obligation. As between the employer and the employee, it's a statutory relationship. It's a statutory obligation. As between me and the employer, it's a contractual lordship.
But whatever injury or compensation is to be paid to the employee, that is to be paid by the employer.
Yes,
and you are to indemnify, is it not?
I am to indemnify only to the extent of the policy, lordship.
Yes.
So, but lordship, the order that is in pass,
I've been made liable for the entire amount as per the act.
But that is not the question you have
That cannot
framed.
be same as the liability under the policy. Liability under the policy is a different matter. That's why this in this case of Supreme Court that
Then what
that
is the difference between question number A and question number B?
almost the same, Lordship. Whether in the given facts, the insurer, appellant as the insurer has, where the appellant as the insurer has no statutory duty to pay compensation to the workman, does the compensation commissioner have the jurisdiction to determine how much is the appellant liable to pay under the policy?
You are
So he's created
submitting on B.
Yes,
You are submitting on B. What is the difference between A and B?
oh, that's the same.
Then
I'm trying to explain both. Lordship may take any one of them. And C is a different question altogether. That he cannot do C, Lordship. He has to take the assistance of a doctor. Under section 41C of the Act, WC Act. He cannot determine it himself.
Mr. Learned Counsel for the appellant. This appeal is preferred against the so and so. The appeal is admitted for hearing on the following substantial questions of law. Whether, number one, whether the Commissioner for Employees Compensation has the jurisdiction to determine the quantum of compensation that the insurer is liable to pay under a policy of insurance between the insurer and the employer, and direct the insurer to satisfy the award. But two, whether the Commissioner for Employees Compensation acted without jurisdiction by determining loss of earning capacity without any medical evidence. Full. Notice to the respondents. Saves by speed post ready. 3 days. The records list.
Also, there's an application for stay also.
Are you not required to deposit some amount?
No, sir.
Huh?
No, Lordship.
No.
No, Lordship, because there is a decision of this Honorable High Court. Earlier, we used to, Lordship, when I had started the practice, we used to pay. But about 20 years back, there was a decision of this. From that time, in no these cases, MFA's, Lordship.
But isn't there a stipulation under section 30?
Lordship, but Lordship, we are bound by a decision of this Honorable Court, Lordship. And ever since, Lordship, High Court accepts the year without deposit. Earlier, that was the practice. For the last 20 years,
But this proviso is clear.
yes, that was the, as I'm saying, earlier I used to do it. We all used to do it. Now no one does it because the decision of the Honorable Court is being followed.
Where is that?
So I'll give it to you tomorrow. Separate. The matter had gone to even Supreme Court, Lordship. The Supreme Court did not touch this part of the judgment, Lordship. That's it remains.
All right, you show us the judgment. We'll list the IA again on Friday.
Friday.
Yes. If you want later.
Maybe it may come next week. Friday I may not be there also. This next week. But.
IA number so and so, please the matter again on
Any week next
so
week.
and so, on which the learned counsel appearing for the applicant appellants and produce the judgment of this court regard to requirement stroke non-requirement of deposit of the awarded amount as per section 30 of the Employees Concession Act. Yes,
Next.
again on.
Next week, Lordship. Apply.
Next week or next week में
Hello. My lord, I have found out some substantial question of law. It is at page number 8, my lord. Here, only the issue number 3 and 4 is required, not 5 and 6, my lord. 5 and 6 is already decided in favor of the plaintiff, but 3 and 4 is, I found that it is a perverse
Page?
consequence. Page 8, my lord. This issue number 3 and 4 is required to reconsider, my lord, because 3 and 4 is against the plaintiff and that is not the in accordance with the law, my lord. That issues are, my lord, at page 69.
Page 8, there is only one issue, substantial question of law.
No, 2 issue, my lord, here. Only 3 and 4 is required, my lord.
No, you have formulated a substantial question of law
My lord.
at page 8 bottom.
Yes, this, whether the findings of the learned first appellate court in respect of issue number 3 and 4, 5 and 6 is not required, my lord. Issues are page 69, my lord. Issue number 3 is whether the plaintiff has right title and interest over the suit bheti. It is a bheti, my lord. Bheti is provided by the Anshalik Panchayat to run a business over the market, my lord. And issue number 4 is whether the plaintiff has given the suit bheti on rent to the defendant, my lord. This issue was redundant by the strike off, my lord, by the London trial court, and thereafter the same view has been taken by the first appellate court, my lord. That's why these 2 issues is required, my lord. And bheti was provided, my lord, by annual patta, my lord. So annual patta has right title and interest, my lord. That was wrongly decided here, my lord.
Your question is so long that by the time we finish reading it, we forget what is in the first few lines.
My lord. It is a question of bheti, my lord. Bheti was given on patta, my lord, to the plaintiff. And the plaintiff, that bheti was given on rent, my lord, to the defendant. And subsequently, he has not handed over the bheti to the plaintiff. That is the main dispute, my lord.
That was provided by Anshalik Panchayat, my lord.
So it is the finding of both the courts below that you were only given an annual patta, exhibit
ma'am.
1.
Yes, my lord.
You could not show that it was renewed on any subsequent year.
Yes, my lord.
So what is wrong with the judgment?
My lord, thing is that I have a case law, my lord. The non-renewal of the patta does not extinguish his right, title, and interest from the unless it is cancelled, my lord. I have case law, my lord, regarding this. And the findings of the learned trial court below, as well as the appellate court, is not that it is not renewal. The finding is that as it is an annual patta, he has no right, title, and interest. That was the finding.
So you are only on the finding on issue number,
Three, and
yes.
4, my lord. Issue number 3 and 4. 4 is wrongly held that I have not pleaded, that I have given out the subjective on rent, my lord. But it is there in the plain.
Yes, where is the judgment?
My lord. Yes. Thousand 31 GLT 376, my lord. It is para 39.
This is on Rayati Khatians. Will it be applicable to Panchayat markets?
My lord.
This judgment pertains to Rayati Khatians.
Righty Khatians, and it is also given by the same spirit, my lord. It is given by the deputy commissioner on same way, my lord. It is annual patta, my lord. This is a patta, my lord. Patta is given same way, my lord.
All right. I don't think we need to. Issue number 4 is not required to be decided here.
My lord,
Is it
it is
sufficient?
sufficient, my lord.
Senate counsel for the this second appeal has been preferred against the concurrent findings of the learned courts below. I'd give the two judgments and orders again. Trial court and appellate court. On hearing learned counsel and on perusal of the bill and impugned judgments, the appeal is admitted for hearing on the following substantial question of law. Within whether the learned courts below were correct in holding that the plaintiff appellant had no right, title, or interest in the Betty. In view of non-renewal of the annual patta by the, what is this, Gau Panchayat?
Anchalik Panchayat, my lord.
Anchalik Panchayat.
Actually, it is given by the Mohkuma Parishad, my lord.
All right,
This
Mohkuma
patta is
Parishad.
given by Mohkuma Parishad.
The absence of any order of cancellation of such patta or notice of non-renewal. Question mark. Issue notice to the respondent steps by speed pursuit AD within 3 days in the time call for the TCR list. Again,
Under one, which case is there, I pray for the injunction, my lord, in this petition, my lord. A notice may be issued and, my lord, status quo may be ordered, my lord. There was a
who
status,
is in possession now?
my lord.
Who is in possession now?
And the possession, actually, he is in possession, but it was restrained in the learned trial court, my lord, because there was an injunction passed in that court, my lord.
No, whatever be the case, today he is in possession. So what status quo is required by you?
My lord, so he may not be allowed to hand over the say to other person also, my lord. Because the earlier status quo order is
IA
there, my lord.
4196. Our learned counsel for the applicant stroke appellant. This is an application under Order 39, Rule 1 and 2, RW Section 151 CPC. Praying for an order of temporary stroke ad interim temporary injunction against the opposite parties. The connected second appeal has been admitted for hearing. Issue notice on the IA to the respondent opposite party. Para. Status quo with regard to the suit land will be maintained until further orders. List again on MD.
Oblige, my lord.
Lordship. This item is otherwise ready for hearing, Lordship. LCR has also been received. Fixed for hearing.
It was sent for mediation.
Lordship, it could not take place.
Huh?
Communication gap was there, could not, I think we missed that date, Lordship.
Mediation did not take place.
It took place, but it is-
Failed.
I have seen the report, Lordship.
Failed.
There no one appeared.
No one appeared.
It failed basically. Let me fix up for hearing also. We need a lot, your Lordship says.
Here's for the respondent of today also. What is the matter? This is for enhancement. Well, no, you are for
No,
the,
I have
you are the
not
appellant.
taken notes. I'm denying my liability altogether because he is not a third party as far as we are concerned. He was the owner of the vehicle we had insured. Thus, decided on a basis of contributory negligence, 50% from.
Third, Mr. Goswami learned counsel for the appellant. None appears for the respondents. It appears that the matter was referred to mediation, but due to non-appearance of the parties, mediation failed. Matter is otherwise ready for hearing, hence list the matter for hearing on.
Oblige.
Your lordship, we have filed the affidavit, but it is not in the record. Kindly fix the matter after a week so that it can be brought on.
Affidavit of Dusty.
Yes, your lordship. Regarding respondent number 3.
Learned counsel for the appellant submits that affidavit of Dusty service has been submitted, but the same is not on record. Registry is directed to check the said affidavit with the record and list the matter again on.
Much obliged.
Item 3.
Please, your lordship. My lord, here, my lord, a very voluminous case, my lord, the challenging a order, my lord. Was in the execution case, my lord. Case 23, my lord. Before that, my lord, there was a direction from Honorable High Court, my lord, case 59. My lord. It's a case of wrongful dispossession in execution of a decree, my lord. It was a case of wrongful dispossession of the objectors. My lord. We are the objectors, third party. We have been wrongfully dispossessed from 3 lesser of land, my lord. Therefore, your lordship will file page 59, my lord, for the time being. Earlier, there was a revision before the Honorable High Court. That was filed by the respondent, my lord. It was initially filed by the respondent decree holder, my lord, against the direction of the executing court to make a measurement of both the land. Now, here your lordship will find the relevant portion, page 62, my lord, para 10, my lord. May I read it, your lordship? Revision of filed by the decree holder was dismissed, my lord, not entertained, and thereby the earlier order of the executing court was upheld, my lord, without interfering. So that order, your lordship will.
So this page 59 order.
Yes, lordship.
So the exercise of demarcating the land was directed to be carried out and only thereafter restoration of possession was directed.
Yes, lordship. So, so that order, your
So that
lordship.
verification process has been undertaken.
Yes, lordship.
Undertaken, my lord, but the executing court could not, my lord, appreciate the facts, my lord, in proper perspective. So your lordship, basically we have challenged that, my lord.
Which is the impugn order?
Impugn order, page 23, my lord. And there are several reports which are annexed here, my lord. I have to take your lordship to order.
Not
Page 117.
Impugn order is 117.
Yes, lordship. Dated 2/5/2022. That question was not determined by the executing court. Regarding, my lord, as we are the owner of the three lesser of land, wrongfully dispossessed. A long order.
Yes, so what remains for you?
Lordship, you see, my lord, the court, the learned executing court were directed by the earlier court, my lord, High Court, my lord, that if that executing court has the power to restore the possession, my lord, if we are wrongfully dispossessed.
But you are not wrongfully dispossessed according to the report.
That report, your lordship will kindly see page 100, my lord.
We won't go that far. What
Your
is 100?
lordship, my lord, I have another prayer here. If your lordship allow me, I'll file a brief synopsis, my lord, linked with the order and the report, my lord. So there are several reports, my lord, and it is very voluminous, my lord. Page 100, your lordship will find that report, my lord. Your lordship will see that area of land, my lord. May I read, my lord? It's a type copy, my lord, translated and typed. In connection with case before Munshi Naman Judicial Court, as per direction Honorable Court dated, so it is to inform you that under Dibrugarh Town Moza, so and so, mentioned in Patta number 158 and Dag number 436, that is the decree holder land, my lord. Area of land is 2 Katha 3 Lesser. And in Schedule B, under Patta number 159 and Dag number 441, that is the objector land, my lord. Area of land is 3 Lesser. Has been measured by the then official staff of this circle office along with civil Nazi, and thereafter the boundary of land have been shown to both the party. The aforesaid measurement, the first party put his signature, whereas the second party objected and refused to sign there. Now your lordship will see the area of land which the circle officer has, my lord, withhold. Your lordship will kindly see page 105. Page 105. This is different, my lord. Your lordship will see. May I read this? This was again intimated to the petitioner through RTI. As per revenue record, Dag number 436 covered by periodic Patta number 158 contains 3 Katha of land, my lord. Whereas in the circle officer report, my lord, it was stated that 2 Katha 3 Lesser. So they have not measured the land, my lord, from the edge of the, my lord, drain, my lord. There is a drain.
These are discussed in order dated 2/11/2016. Lord.
This portion has been, my lord, never appreciated, my lord. Your lordship see, because I have been dispossessed of 3 Lesser of land. So to find out, my lord, the actual measurement of both the Dag number and Patta number of the decree holder as well as the objector, your lordship will see page 105 was 3 Katha of land, and adjacent there is another Dag number 703 under same periodic Patta contain 2 Katha 3 Lesser of land. Both the Dags are falling under Marwari Patti. Now after this, we have placed that, then your lordship, page 106, the lordship will see, as per page 106 is another report which says, my lord, as per direction of the Honorable Court of Munship number 1 in title execution so, accordingly on 13/6/2016 visited the land under Dibrugarh Town Moza, Marwari Patti ward, and following court order, the Schedule A land covered by Dag number 158 and Dag number 436, area of land is 2 Katha 3 Lesser has been measured. So there was 3 Katha of land, my lord. So they have not measured the actual measurement of both the land, my lord, and submitted an erroneous report, my lord. Now, your lordship, one more, my lord. I will place in detail in a synopsis, my lord. Your lordship will see page 109 also. Your lordship will see page 109 under para number 1 under Dibrugarh Town Moza Marwari Patti Patta number 158 Dag number 436 that belong to decree holder. Area of land 3 Katha have been found. 3 Katha land has been there, my lord. So they have to measure that and the aforesaid dark number do not contain 2 katha 3 lesser of land. Specifically stated, the aforesaid dark number do not contain 2 katha 3 lesser of land. But the earlier circle officer, my lord, page 100, your lordship, he has measured the land, area of land 2 katha 3 lesser. There is certain, my lord, things which have not been considered by the executing court, my lord. The correct position. So my submission, my lord, is the actual measurement of the.
Who are you? Who are Anandram Telly, Shivakumar Telly?
They are the degree holders.
They are the degree holders. So the land has been found in their name.
That is there, my lord.
Yes, Lordship, even after execution of the.
We are not against there, my lord. Decree has been executed, but while executing that decree, my lord, the bailiff went to the land while handing over the suit land, my lord. In addition to that, dismantle our 3 lesser of land. And that 3 lesser land, my lord, has to be ascertained because that is under the decree holder now. We are the third party, my lord. We are deprived. Now, order 21, my lord, all questions has to be determined in the executing court, my lord. So therefore, earlier High Court directed to make a specific demarcation of 2 boundaries. Now, what happened, my lord? This circle officer, he has only measured 2 katha 3 lesser without considering the 3 lesser of 3 katha of land. And this report has not been totally, my lord, taken into consideration by the, my lord, earlier in the impugn order, my lord. So your lordship will permit, then I will submit a detailed synopsis, my lord, along with the reports, my lord.
But the order says both the lands were measured.
Both the lands has been measured.
Here is DAG number 441 and PP 159.
Yes, yes. That is the thing, my lord. How much portion of land that has been, that has to be discussed, my lord. This was never done, my lord, because the circle officer report dated 2/11/16. That is not correct appreciation, my lord. Therefore, we have paid, our petition is there to make a proper demarcation and measurement. Because we have been wrongfully, my lord, disposed of land. That is the thing, and we cannot have other remedy, my lord, except the executing court, my lord. We don't want their land, my lord. We are only claiming our land 3 lesser by way of proper measurement and survey, my lord.
The decretal land, I think this is the.
Yes, what is your submission?
Humble submission is that there is no jurisdictional error in passing the order under challenge, lordship. Since even after satisfaction of the decree, twice the plots were measured, land as well as the decretal land later on pursuant to compliance of High Court's order. So, lordship, your lordship will find the thing very clear in page number 120, lordship. Para 3. Para 3, page 120. The matter ought to have stopped on 2/11/2000. 2/11/2016 is also a detailed order, lordship. Right, lordship. And the petition has no challenge also reports, lordship, of the civil and the revenue steps.
Challenge a order pass impugn order.
That order is not challenged, lordship. 2/11/16 order.
That is not an order, it's a report.
Information, the order under challenge is.
That order, that report has never been discussed, my lord. that there was 3 lessor of land, my lord. Actually, as per the documents we have submitted for, there are 3 lessor, 3 kotha of land, my lord.
All right, but you want to file some compilation?
Yes, my lord, because it's very difficult for me also to draw to all this. I will sequence once, I will file a compilation in a synopsis for better appreciation of the lordship. 10 days time will be given.
On the prayer of learned counsel for the appellant, list the matter again on so and so in order to enable the learned counsel to file a synopsis and list of dates describing the sequence of events. Learned counsel for appears for respondent. All respondent. All respondents. List again.
8 April. Publish.
May I please report? In this case, respondent number one expired. So you need to subscribe the subsequent petition, but we have not received the name of the respondent number one. Legal have the legal of respondent number one words. Legal here of the respondent number one name have to be provided by respondents lordship. They have to provide it, but they have not provided us. And in regard 1920 service has not been served lordship.
Learned counsel for the appellant submits that the details of the deceased respondent number one has not yet been furnished by the learned counsel for the respondents. Full stop. Today none appears for the respondents. The earlier occasion time was granted to learned counsel for the respondent. One is the details of the legal heirs of respondent number one. Full stop. Learned counsel for this respondent number one is given one more opportunity to furnish the names of the legal heirs of this is respondent number one. Is the matter again on 4 weeks.
Pastor.
If as per office note dated 22/26 lordship, respondent one file wakalatnama for 2 lordship, you have to await service report. Receipt.
My lord, this is a case of 2019, my lord. And till now, one order was there on 29/11/2019. And till now, they are silent, my lord. They have taken notice and I have some submission, my lord.
I'm not silent, lordship. The court asked me to take steps. I have taken steps.
No, 6 years, my lord. 6 years.
No, we took step. There's no lead. Office notice of now. Lordship, I don't understand what allegation is being made.
We should pursue, my lord, for the case now. So many cases are there. I have pursued. That is why these cases are listed, my lord.
You have pursued after 5 years.
I was waiting, my lord. They are appellate, so they will pursue. I've told
No,
her
they
several
appear-
times. I have told her.
They appeared in 2019, lordship. Respondent one
But
appeared.
She has filed. My lord, at the time of admission, I was not there. I have not appeared. Thereafter, I appeared.
Lordship, as soon
So-
as service on respondent number 2 is over, lordship, if it is over next week also, I'm ready to do the hearing, lordship. I'm ready to do hearing.
I have my submission, my lord, that at that time of evidence, they have not given, they just exhibited the verification report. They have not adduced any evidence to prove the verification report, my lord.
Lordship, the court
And
came to.
one One thing is there, my lord, the owner have driving license, my lord. I have got now. My client, when pending this case, they went the house of the owner and got the driving license, my lord. The owner told that, see, he got that is no rejection from Nagaland, my lord. And then he applied in the Nagaon district DTO office, and then he got the license. That is the license, my lord.
Owner never appeared in the tribunal, and here also we are waiting for the
And
owner
my
driver.
client is,
Lordship.
my lord, she is now old. She was dependent on her son. This is the license, my lord. The owner has license, my lord. Here now, my lord.
How the license can be produced this way, Lordship? I
have
don't
given.
understand.
My lord, on 29th, my lord, 4th February 2026, my lord, Calcutta High Court given a direction that insurance company cannot recover compensation without hearing vehicle owner on alleged policy of violation, my lord. On 4th February 2026.
We are waiting for the owner itself, Lordship. The respondent number
They
2
have
is
not
the
heard the owner. Even they are investigator also here, have not visited the owner house. If they are investigator visited the house of the owner, my lord, they collect this driving license. They can collect. And the my lord claimant also got the money, and there are also insurance company interest of the interest amount also, my lord. These are the public money.
So your only case is that he had no driving license. So you have to recover
Yes.
then.
Lordship, that is to be as per Nanjapan. That's why I'm saying, Lordship, we want a hearing date, no issue. But the owner is not appearing. He did not appear in, and if it is deemed served, the notice, Lordship, then we can proceed with the hearing any day. I'm open for that.
Suppose we strike him out, what will be the result?
Then Lordship, recovery, if it
What
is
is the problem? You will recover from him in a civil suit.
not civil suit, Lordship, as per Nanjapan, Lordship, it will be in the same suit, but recovery will be only when he gives a security.
Yes.
That is the law, Lordship. And that was
Before-
also upheld
Through
by
the trial
some
court,
Lordship.
through the MSCT only.
Yes. Yes. MSCT only. And Shamanna also has upheld
So in
that.
so when he appears in the MSCT and shows this, you are out.
No, he cannot
They
show.
can, yes,
Can I
madam.
submit
My
something?
that they can.
Lordship is asking me, can I submit something by
I'm sorry.
Lordship, to prove that he will need something. It cannot be just like I'm giving a yay and that record has to come.
MSCT will inquire.
Fine, Lordship, no issue. No issue. Lordship can hear it. No issue with me. I'm ready for the hearing. But striking out, Lordship, but not at our risk, Lordship, because we want to await for his service. He is giving a driving license to the claimant, but he is not appearing before this honorable court even after receiving the notice or something like that. I do not know.
Who was the driver?
He is the owner also.
Owner and driver, same.
Yes, same person.
This person.
There is no name in the driving license, Lordship. And the driving license, she has given me also one copy. This driving license cannot stand, Lordship.
This was the original.
2 November to 10 November.
This was the original
2010,
driving license.
1 November to 2030. We have adduced evidence he did not have a driving license on the date of accident, Lordship. There was a 1 month.
What is the date of accident?
Date of accident, Lordship, was 29/8/2016. And in our written statement itself, a court has mentioned at paragraph 3 also. It was found valid till 31/7/2016, and thereafter the said policy was not found valid from 29/8/2016. It is
That is about policy.
policy.
We are on DL.
Yes, yes. Lordship, I came for orders. I did not come for the final hearing. That's why I'm finding
No,
it
we are,
difficult.
we want to settle the issue. This is a matter of 2019.
The driver did not have.
Can wait for another 5 years.
No. I do not want to, Lordship. I want to finish. In fact, even I am in a pressure to finish off the cases.
Already 10 years elapsed, madam.
They have not gone for any execution, Lordship. They are submitting here. We have not taken any stay, Lordship.
What?
Against the
Execution, yes, my
judgment.
lord.
Insurance according to claim was amended.
My fault is that I have not
action
filed
in,
parties proceeding.
Examined to the support. Lordship, paragraph 12 is there, Lordship. They were Chola Mandala was made the party, then they were they were striked out and national insurance was made. And national insurance contested by examining 2 witnesses, DW 2 and 3, Lordship. And the court at paragraph 16 has come to that finding, Lordship. Let it come for hearing, Lordship, no issue.
My lord, when one document is exhibited, that must be, my lord, proved. The verification report was not proved. That means that verification report was false. That is why
they have not challenged the judgment, Lordship. They have not challenged the judgment.
That is why the owner has got the license from the Naga, my lord. Because the license of the original license of the Nagaland was not fake, my lord. He got there is no objection from the Nagaland, and then he applied in the Nagaon District Transport Office and got this license.
So that owner should come. Lordship, how does the claimant know all these things, Lordship? I just don't understand. Without any affidavit, without any. Owner should come and present his case before this honorable court, Lordship, if he has a valid license.
Problem, my client is suffering. She is an old lady, dependent on her son, deceased son. And the case is from 2016, 10 years. They can proceed, my lord, for execution.
When was the last time steps were taken?
Payment may be made, my lord, and they can start proceeding. Then owner will come and provide the license.
Lordship, when we had taken, I think in 19 itself, we can take fresh steps, Lordship, on 2. By maybe
again time will go, my lord.
The last step was taken on 3/2/2020.
yes.
19.
Because
The matter was not never listed.
Lordship, we will take by Dusty, Lordship, because he is from Nagaon.
All right, that will solve the problem.
Yes,
If
Lordship.
if after that it is not available, we'll proceed.
Yes, Lordship. Because that is the shortest way I can submit, Lordship.
All right.
And regarding hearing, Lordship, I'm not prepared to test.
No, we won't force you to do that. We want only to expedite things
Yes, Lordship.
so that the
Right.
hearing takes place on the next or
Yes.
1 or 2 days.
Fine, Lordship.
Heard learned
Date of
counsel,
hearing
the
may be
appellant,
given.
also heard learned counsel representing the claimant respondent number 1.
One.
It appears from the office note dated 20/02/26 that ID card in respect of respondent number 2 has not been received back, and office note dated 03/02/2020 shows that the steps were taken on respondent number 2 for the first and last time on 3/2/2020. And since then, more than 5 years have elapsed. The appellant is directed to take steps on respondent number 2 by Dusty Service and file a affidavit accordingly within a period of 2 weeks from today.
4 weeks, Lordship.
My lord, and that may be fixed, my lord.
Right, 4 weeks.
Okay.
Please the
That's
matter
all.
again on.
Obliged.
Can direct the DTO to submit a report whether this certificate
Yes,
is correct.
Lordship.
That will solve the problem.
Let's see.
This is
I find-
online, my lord, online they can.
That is
find
why,
out
because
this.
it is online, I am
Yes,
recognizing it for
and
the
their
time being.
investigator can go and.
Why
find
not
out
the
that-
owner come and file a
That
affidavit?
is,
Lordship?
how can I know? How can I
Yes,
know, my
no,
lord?
first.
I think he has all the documents clear, so he did not come.
That is- that is-
Even if he knows, he will say, why should I go there? Let them come against me. I'll show.
Yes, that is the
I
issue.
don't know,
here.
my lord, about.
That is the issue.
Why should he spend money engaging an advocate in the High Court?
Yes, that is the
He
issue.
can wait for you till you go to MSCP.
Lucky that way, Lordship.
Not so blessed.
Item 19. Name has not been shown today also, I think. Last order direction was there to show the name. Oh, second page. No, the P. Mohanta, he has withdrawn. Who is the newly engaged counsel? Wakalat number 2 ক'ত আছে? Newly engaged counsel বুলি লিখা আছে যে। Newly engaged counsel আছে নেকি কিবা? None appears for the petitioner by earlier order dated 9/2/26. It was directed that the name of the newly engaged counsels be reflected in the cause list. In today's cause list, the name of 3 counsel have been reflected as representing the appellant. They are Mr. S.K. Jain, Mr. P. Mohanto, and Mr. P.C. Khetri. But it appears from the earlier orders that Mr. P. Mohanto has already withdrawn from the case. It is not clear as to who is representing the appellant at present. The registry is directed to verify and is the matter again with office note in this regard. This again on
Wait, please, Your Lordship. Your Lordship, in regard to respondent number 1, 2, and 3, service is complete. But in regard to respondent number 4, AD card not received. We will have to take fresh steps upon respondent number 4.
AD card in respect of respondent number 4 has not been received back.
Your Lordship, we will have to take instruction whether to proceed with dusty or paper publication. We are seeking 1 week time.
Learned counsel for the appellant prays for 1 week's time to seek instructions as to the manner in which fresh steps may be taken. Hence, list again on.
Yeah, 123.
When so appears for respondent number.
PD Bhuya. Matsu.
My lord, these matters I appear for respondent number 3 and 4, my lord. My lord, respondent is here. Where respondent is? 1 and 2. I am for 2, man. I'm sorry. I am for respondent number 2, my lord. Yesterday, my lord, I had a talk with Mr. Bhati, my lord, who is representing the petitioners here, my lord. Appellants, I mean, my lord, and he said that he wanted this matter to be fixed for hearing, my lord. Otherwise, we are there, my lord, and service is complete, so let it come up for hearing, my lord, in the first week of May, my lord.
Third, learned counsel for the appellant as well as respondents. All the respondents are represented. Here has also been received. List the matter for hearing on.
It's been the first week of May, my lord. On, my lord, 8th of May, my lord.
7th of May.
7th,
Friday.
7th.
7th of May.
I'm developing.
May I please lordships. This case, my lord, I am the claimant appellant for enhancement, my lord. But at the time of filing this appeal, my lord, I have today, my lord, gone through the record, my lord. It's opposite party number 1 and 2, driver and owner, were not made party. That's why I would like to, my lord, file implement petition, my lord.
Liability is fastened on the insurance company, is it not?
My lord.
Liability has been fastened on the insurance company.
Yes, my lord.
So why do you need owner and driver for enhancement?
My lord, necessary party, but
what business do they have?
Sometimes, my lord. Today is fixed for my lord order, my lord.
Why burden the court with extra paperwork?
My lord,
This is the matter for hearing if parties have appeared. TCR
yes,
is
my lord.
received. Yes, TCR is also here. Heard learned counsel for the appellant and learned counsel for the respondent. TCR has already been received. Please the matter for hearing on.
My lord, in the case, my lord, in 2000, my lord, 2015 matter, my lord. And there, my lord, they are suffering, my lord, since 2015, my lord.
This is why we are listing for
That
hearing.
time, my
It
lord,
is you who wants to
hearing, my
delay.
lord, but date may kindly fix my, that's my humble prayer, my lord.
Have you seen any case in this court where date is not fixed?
My lord, date may kindly fix.
After beautification.
Obliged, my lord, much obliged.
Is a lordship. Lordship, in this matter, service is complete. The matter may be fixed for admission, lordship.
You are for respondents 2, 3, and 4.
Yes, lordship. One or three letter.
Then 4, lordship. 2, 3, and 4, lordship.
Service is complete on 1.
Yes, lordship.
You were supposed to obtain certified copy and file affidavit of the title suit. Have you done that?
Oh, lordship, that was not been filed out. And lordship may allow us some time to file the affidavit, lordship.
Learned counsel for the petitioner and learned counsel representing respondents number 2, 3, and 4.
Pardon, lordship. I'm on the 1, 2, and 3.
Last order reflects your
Lordship, for respondent number 1, there was a caveat, lordship, and he have appeared to a caveat, lordship. He is a.
So you are representing 1. Are you sure?
Then 4.
You don't know who you are representing.
Then 4. I'm.
Yes.
So,
One is caveator.
Yes, lordship.
AHMR Chaudhary.
Yes, lordship.
Where has he gone? Learned counsel also representing respondent number 2, 3, and 4. It appears that learned counsel Mr. AHMR Chaudhary represented the respondent number 1 stroke caveator. Whether caveat has been discharged.
Lordship. Caveat number is 1352, stroke 2022.
ওটা দেখো হয়নি। শো করো নাই। This item 25. Whose name has been shown in the cause list. Full stop. It is reflected in the order dated 12/5/23. Learned counsel for the petitioners, Mr. S.K. Ghosh, had submitted that he had obtained the certified copies of title suit number 55 of 22, and he was to file affidavit in this regard. The learned counsel appearing on behalf of the petitioner prays for some more time to file the required additional affidavit. Hence, list the matter again on.
Complete.
26.
Lordship, kindly permit us to correct the serial number of the cause title of the respondent and performer respondent. And we will take step within a week.
Learned counsel appearing for the petitioner prays for some time to correct the names appearing in the cause title as they were wrongly arranged earlier, and to take steps accordingly. Prayer is allowed. List the matter again after 4 weeks on.
Actually, there is an omission on my part, my lord. I have to file one IF for correcting the name of the respondent number 7 and 8, my lord. I may be allowed to file.
Learned counsel for the appellant prays for some time to file appropriate application for correcting the names.
My lord, in fact, my lord, status of those persons, 2 persons are 7 and 8, my lord, in respect of a particular vehicle, my lord. Because in those
Correcting the status of the respondents number 7 and 8. Respect of the vehicle.
What have been shown as driver, my
for respondent.
But
All
you must be paying
respondents.
for respondent number 4, Your Lordship.
Number 4. What about others?
Service is complete, my lord, in other cases.
Service is complete in respect of other respondents, remaining respondents. Hence, list the matter again on.
I live.
10 hour 28.
Yes.
In this case, I filed an application for substitution of the legal layers within time. Then response number 2 was directly to be served, but the response number 2 was earlier in the trial court itself. He was made ex parte, so his name is struck. He's the owner.
Heard. Mr. So learned counsel for the applicant. It submitted that as regards service of notice upon respondent number 2, comma, the said respondent had not appeared appeared at the trial, and the case had proceeded ex parte against him. Accordingly, his name may be struck off. Accordingly, the name of respondent number 2 be struck off. So what is this application for?
This is for substitution of the legal layer. The parents.
And there is delay.
No delay. Within time.
What is this application for condonation of delay?
That is for the appeal, Lords, main appeal.
Main appeal.
Yes. Then that substitution petition is IA number 1917.
So after filing of the appeal, this
Yes, Lord.
date has occurred. This order is in IA 1758, Between Metro Delhi. 58. IA number 1917. Third learned counsel for the applicant. This IA has been submitted for substitution of the legal heirs of the appellant, who are as follows. Paragraph
2.
Huh?
Paragraph 2.
Paragraph 2. Did you want?
Lordship, I'm sorry, Lordship. Here in paragraph 2, the address of the parties have been wrongly mentioned. It is due to copy and paste, Lordship. I want to correct it, Lordship. Correct address has been given in the post title, but not in this paragraph.
So we can't dispose of this today.
Yes, Lordship. I have to make the correction.
Well, let's cut that part. IA 1917 learned counsel for the appellant. Applicant submits that the address of the legal heirs of the deceased appellant has been wrongly stated in the instant IA.
The paragraph 2, Lordship.
That paragraph 2. And the same is required to be corrected. Applicant to file appropriate application accordingly. Paste again on. None appears for the applicant. By order dated 5/5/25, applicant was directed to take fresh steps on respondents number 5 and 7. But office note dated 10/12/2025 indicates that no such steps have been taken. Therefore, the applicant has failed to take steps even after 7 months of the order at 5/5/25. On call, none appears for the applicant. Is accordingly dismissed for non-prosecution.
Actually, this case was settled, but today the delay condonation petition will come. So, I submit the first delay may kindly be condoned, and we will file the fresh affidavit in respect of the settlement of the case.
Any objection filed?
No, my lord, because it is already negotiated. The advocate of the applicant and the company. But since the claimant did not appear on the last occasion of the National Local Adalat, so could not be settled. Even that she also not appeared before the company to submit the necessary.
We'll file a fresh affidavit on that respect.
So today maybe 225 days may be called now. 225 days.
At learned counsel for the applicant and also learned counsel. Respondent number 1.
Number 1, insurance company.
An application for condonation of delay of
225 days.
and 25 days in preferring the appeal against the impugned judgment and order dated 19/11/22 passed by the learned member MSCT number 2 Kamrup M in MSC case number 2139 of 2018. Objection has been filed against the instant application and learned counsel appearing for the number 1 submits that the delay may be don't the perusal of the grounds, perusal of the reasons for delay as stated in the instant application supported by an affidavit. I am of the view that the appellant was prevented by sufficient cause from approaching within the period of limitation. Having regard to the same as well as the absence of objection from the delay, I stands allowed. Release the connected appeal for TCR.
LCR call for MSCT 2 Kamrup Gauhati and also list after 4 weeks.
So actually there should be the appeal should be registered, Lordship, first.
The registry is directed to register the appeal.
And name of the respondent may kindly be shown.
My name is my lord, respondent number 1. I'm APR for respondent.
Name of respondent number 1, Mr. So and so be shown in the cause list. Your name is shown. At council, Mr. Swen appears for respondent number 4. This is a deliverable. What's it? I don't know. Which the rule?
Okay, this is a continuous delay petition for 212 days, Lordship.
Yes, any objection?
I'll file objection, Lordship. Service is also not complete, Lordship.
Respondent number 3.
Not returned.
Huh?
Service is not returned, Lordship. If delay is
You are for 1 and 2.
I'm for 1, Lordship. 2 and 3 not served, I think.
2 is left, Lordship.
Office note dated 29/1/26. There is office note, Lordship. The office note 5/4/24.
2 and 3 are what? Owner driver.
Owner drivers. So
You are for enhancement.
enhancement, so they can be deleted. No problems.
Our learned counsel for the applicant. This is an application for condonation of delay 212 days. Learned counsel representing respondent number 1 insurance company is present and pressed for time to file objection. Respondent, the connected appeal has been preferred, seeking enhancement of the awarded amount. The liability for payment of the same has been fastened on the insurance company stroke respondent number 1. Hence, it is prayed on behalf of the applicant that the names of the respondents number 2 and 3 may be struck off. Accordingly, the names of respondents 3 are struck off. It will be corrected accordingly. List again on students.
First applies, Lordship.
My lord, I'm respondent number 1. There is a delay of 451 days. I need to file my lord. So might be allowed for this.
About service.
Service, Lordship, respondent 1 appeared and 2 and 3 not served, Lordship.
This is also enhancement.
Enhancement, Lord.
So strike them off.
From the delay petition, Lord.
Same order.
Last time, Lordship, also they were given chance twice for filing objection. In the year 2011, 25, 22/8/25. So insurance company not filed any objection.
Look, I filed in my Okaratnama in 19/1/24. Then it is listed on 5/6/24. Then today is listed, my lord. I took time only one.
No, Lord,
So give me the forest.
office note dated 20.
All right.
11/25. May
No
kindly
waste
be
time
seen.
on that. 31. Edit.
Lordship pleases. Opponents have already entered appearance. Can be fixed for admission hearing anytime.
All parties are represented.
My lord, where I'm representing my lord. Yes, ma'am. For all.
All right, all the parties are represented. Place the matter for admission hearing on.
Admission hearing, my lord. Make it be disposed of in the admission hearing.
Admission hearing.
I don't know.
8 April.
Give it on a hearing day.
My lord, it admission hearing, my lord.
Hearing day at a video admission.
9th April.
Right, is lordship. My lord, in this case, my lord, service may be my lord completed, but respondent wife is not appearing. So kindly matter may be fixed for another date for admission hearing. My lord. Wife filed, my lord, husband filed one restitution application, my lord. Therefore, wife has come before this honorable court praying for transfer of this case from the family court, Kachar Silchar to Hailakandi.
Who has filed this petition?
My lord, the wife, my lord.
Case is pending.
Pending, my lord, family court, Kachar Silchar.
And
Restitution of conjugal.
where is
right.
it required to be transferred?
My lord, district judge Hailakandi, my lord.
Tilsur to Hailakandi.
Hailakandi. She is, my lord, presently, my lord, expecting mother, my lord. There is a problem. And two other cases she already filed before that CGM Hailakandi, my lord. Both are being contested by the parties, my lord. Sir, also. I have stated, my lord, at paragraph 2, my lord. NHR 1 and 2 are those two cases, my lord, I have annexed, which have been filed, my lord, petitioner, the court of CGM Hailakandi. Ground parts, my lord, I have stated at paragraph 8.
You're still expecting.
Yes, perhaps, my lord, today I have not
Since
taken instruction, my lord.
your date was in December 2024 and you are still expecting.
My lord, then, my lord, today I
The
have.
kid will go to school straight from the womb.
Yes, my lord, it is 2024 matter. Perhaps, my lord, he is not interested, my lord, no objection, because two other cases are pending.
So anyway, he has to go to Hailakandi.
Yes, ma'am. Paragraph 8, my lord, I have stated the circumstances.
and heard learned counsel for the petitioner. As per office note, service of notice is deemed to be complete on the sole respondent. Application under section 24 of civil procedure, praying for transfer of FC civil case number 495/2024 pending in the court before the principal judge family court at Silchar to the court of the learned district judge Hailakandi. It is stated that paragraph 8, page 7. Okay. Submitted that although he has no current instruction, but the child may have already been delivered by now, since nearly 2 years have elapsed. More than 1 year has elapsed since the filing of the instant application. In regard the averments made, and since the sole respondent has not appeared to pose the prayer, the petition is allowed. The so and so case number hereby stands transferred to the court of the learned district judge Hailakandi. The records be transferred forthwith of this order to the learned judge family court at Silchar, Kachar. Hence disposed of accordingly. Diploma.
And for the respondents, my lord, service complete for admission hearing.
For the respondent, sole respondent.
Sole respondent.
List for admission.
My lord.
Heard learned counsel for the petitioner and learned counsel for the sole respondent. List the matter for admission.
Can it be 2nd April? Right, please, Lord. My lord, here in this petition, my lord, I have filed an affidavit that states affidavit on justice service, my lord. Your lordship may be pleased to see page 100, my lord.
Yes.
What happened, my lord, in this matter, this is a revision petition, IO, against the order of rejection of our prayer for amendment of the plain, my lord. So we filed a revision petition here, and notice was issued. As per the honorable court's order,
we took steps on the respondents by trustee service as usual as by also by postal service. But these were returned, not being accepted by the respondent, my lord. And they are also delaying the matter in the title suit itself also, my lord, not cooperating. They are causing trying to take the directory practice here, my lord. What happened, my lord, then? We got an order from this honorable court for making dosti service. Accordingly, dosti service was taken after being prepared by the High Court registry. But your lordship kindly see, again, the respondent is refusing to accept it. So there is no alternative, my lord. And private respondents, 1 to 3 are the private respondents. So we took, as per honorable court's order, or private respondent 1. Government respondents, they are always ready, my lord. They are ready. And in respect of respondent 7 to 14, my lord, I have also made a prayer for not taking service on them, my lord, because they are not contesting the case before the court below. So, my lord, your lordship may be pleased to take our, accept our prayer for admission of the matter after I accept the notice. It is up to the respondent, private respondent, they are not intentionally avoiding, not coming in to court, my lord.
Why not paper publication? Had the service been accepted, different thing, but now you say they have not accepted.
My lord, your lordship,
They'll let her come and say
this is there, my lord. Your lordships, they are very much available. Kindly read my prayer, my affidavit. We took the steps as being prepared by the High Court yesterday, but the lady concerned is not accepting. So there been no alternative. We obtained the signature of the witnesses.
It is your word against theirs. The later stage, they will come and say we didn't.
My lord, if you take the poor people, my lord, if they go for the paper service in this thing, then the title suit is pending. They are trying to delay, trying to cause the delay, directory practice here, my lord. So, accepting our dosti service, the matter, they are not interested.
If the case is pending, we can have it served through the court there itself on the next date.
My lord?
Through the court, if the case is pending there.
This is after your lordship. Your lordship passes an order in this respect.
No, I had a look in the case itself today. Our government records are also, the court below has already recorded. I mean, the schedule itself is 29 pages long. So this is not a court of evidence, my lord. It'd be proper to allow this case to go on. I mean, why can't they file a fresh title suit, my lord? Looking at the case, I had an idea that it would be better if they file a fresh case, my lord, as the lower court has already pointed out, and they are not taking the good advice there. The lower court has given a good advice, in fact. That will simplify the things. And the schedule is, my lord, can have a look, is 29 pages long. This is not a court of evidence, my lord. This is already 2 years of delay.
This is the matter before to be agitated before the courts below, my lord. My learned friend from the government side is arguing, but the response is not, the private dependent are not cooperating. They are avoiding.
So they may have got a fright also, my lord, because it will become very complicated. And what the lower court has stated in the order, and our records are matching in fact, to extent.
We first have to solve this issue.
Not a bigger complication is there. The notice itself has become a big complication.
When is the next date in the case? Is it proceeding?
My lord?
Is the trial proceeding?
Trial is not proceeding because we sought for amendment as per honorable court's order. The proceeding is stayed, man. After filing the IO.
So they are not appearing in court, so no question of serving it through the court there.
my lord, stay is there, my lord. So that is not very unfair, my lord. The court case is stayed.
Unfair to whom?
The sides, my lord, and is paying for that.
All right, we'll pass order. Let's see what solution can be.
Because these things may be intentional also, my lord. That is what I'm worried, my lord.
That will pass orders.
Obliged, my lord.
Please, Your Lordship, as per the information petitioner, and both the parties have settled down the matter. Kindly allow us to withdraw this petition, Your Lordship.
You are,
Petitioner, Lordship.
your name?
Aim Saikia, Lordship.
AM Saikia, learned counsel for the petitioner, submits that the matter has been settled between the parties and seeks leave to withdraw the instant petition. Accordingly, the petition stands dismissed on withdrawal.
Item 36, I'm appealing for respondents 456. PK Bhattacharya. 6.
My lord, will you kindly peruse the office note, my lord, dated 7/3/2026. My lord, in fact, we filed a caveat, my lord, and copies were served to us, but our names were not shown in the cause list. There's notes, it says by mistake, it was not placed, our caveat was not placed. So notice was issued, my lord, in our absence. And the further proceedings was also, there is an interim order also. So, my lord, I'm not going on that. What I pray, my lord, my other side is also absent. This may be fixed for admission hearing. I'm not praying for recalling of that order because in our absence, the order was passed. But what I'm praying is to fix the matter for me with some urgency, my lord. There's a landlord-tenant dispute and they lost both the courts below, my lord. There is a concurrent finding. Our bona fide requirement is very pressing, my lord. Therefore, if lordship fix the matter for admission,
None appears for the.
No, my lord.
Oh, you are appearing. Okay. Counsel for the petitioner and Mr. Central Learned Counsel. Sole respondent.
No, all the respondents.
As prayed for, list the.
Today, my lord, my name has not been shown.
As prayed for by the parties, list the matter for admission on next week. Next week.
23 to 25 নাম আগত বা পিছত
25 or পিছত দি দিয়ক তেনেহ'লে
and there is an interim order.
Interim order passed earlier to continue till the next date of listing.
Case for office note dated 9/3/26, lordship. 46.
Respond number 1.
ID card not received in respect of the respondents. LCR is not come, lordship. So reminder for LCR and respond number 1, appear, lordship.
Hard learned counsel for the appellant and for respondent number. Therefore, one.
We have not received a copy.
I'll give lordship.
As per office note, AD card in respect of respondents 2 and 3 has not been received back. Yeah, wait, LCR has also not been received. List again on. List.
May I please, Your Lordship? As per office to dated 9/3/2026, service not complete, Lordship, except 1 E. Lordship,
You are
service,
appearing for?
My lord, initially respondent 1 and 2, now subsequently, my lord, respondent 1 has died. Now the legal heirs are to be substituted. So I would be appearing for all of them.
All the respondents. Okay. Our learned counsel for the petition. Mr. Swenson, learned counsel, has entered appearance for all the respondents. What is this IA about? Oh,
I is delay condonation, 378 days delay, and
objection.
No, my lord. Respondent number 1 died. Subsequently, we came to know that 1 died. Thereafter, we intimated them, and thereafter they filed their application. So for this transaction, there was a delay. We have no objection. Can be disposed. Delay in preferring the substitution petition for respondent number 1.
IA has been preferred under section 5 of the Limitation Act, concerning delay of 378 days in
8 days.
preferring the substitution petition. Learned counsel appearing for the respondents submits that he has no objection to the condonation of the delay. Accordingly, the delay in referring the substitution application stands condoned. IA stands disposed of accordingly. The other IA for substitution?
3174 is for setting aside abatement.
Abatement.
That also can be disposed of.
Third, learned counsel for the applicant and learned counsel for the respondents. IA has been preferred for setting aside the abatement of the connected RSA number 128 of 2014, which was occasioned due to non-substantial failures of the deceased respondent. The period of limitation. The connected IA for condonation and allowed the abatement of the connected appeal stands set aside and the IA stands disposed of. Then 3175.
Pilot.
Not so and so. IA has been preferred seeking substitution of the legal heirs of the deceased respondent number 1, who are as follows. Paragraph where
Page 7, para 2.
page 7, para 2. The prayer is allowed. The aforesaid legal heirs stand substituted in place of the respondent number. This is the respondent number 1. Petitioner to file appropriate application for correction of the first title. IA stands disposed of.
The second appeal.
The appeal, you write of orders passed in IS numbers so and so, the applicants restored. What was the stage? I feel.
My lord, that was admitted and my lord, LCR was also called for. So it was fixed for final hearing.
Hearing. Did you hearing? Huh?
Obliged, much obliged.
Views. I am in for condemnation of delay of 30 days in preparing the restoration petition. Restoration CRP was dismissed by the Honorable Court on 6/6/2025, and on the date of hearing of this matter, I was unable to appear due to my illness, and subsequently that was rejected and dismissed. And we came to know about the dismissal order on 22/7/2025. Thereafter, certified copy will apply for.
Learned Council, this is an application for condonation of delay and so issue notice to that. That's steps by speed post tweet ID within 3 days. This again, no?
30 minutes. Alia.
I have entered appearance by filing occurrence number today itself on behalf of respondents in his case number I C766. I will be filing objection. Delay condonation application.
None appears for the applicant. Learned Mr. So and so has entered appearance on behalf of all respondents.
All respondents, 2 respondents there.
And 6 time to submit objection. List the matter again on.
Obliged.
Review application come up for the first time, notice maybe.
Third Learned Council for the application for review of order date so and so. Is to the respondents steps by speed post tweet ID within 3 days.
Much obliged.
তো মেনশন কৰোতে ভুলিছে নেকি 45 ৰ লগত এক বেছি এইটা কিছু নেকি ইলু এক পাৰ্টিও একে দেখোন এইটো নকলে নেকি সাপ্লিমেন্টাৰী থাকিল কাৰণে মিছ হৈ একেলগে কৈ দিলে একে অৰ্ডাৰে কিমান আছিল এইটো 38 ৰ পৰা 45 না সেম অৰ্ডাৰ ইজ 38 to 45 44 বেলেগ নেকি এইটো নাই মানুহ none appears list again on
Hearing item number 51.
Please, your lordship. Lordship, here, Mr. and this counsel, Mr. Enalam is appearing in this case for a respondent, one.
Who?
So, Mr. Enalam, for respondent one. So here, he could not appear before his honorable court today due to the demise of his relative, lordship. He has to leave the court, lordship. Unfortunately, we are praying for adjournment to a convenient day, lordship.
That counsel appearing for the respondents, Mr. Tom, suffered a bereavement. Somebody has
It is one, has died, right.
suffered bereavement today. Hence, leaves the matter for hearing. Hearing date or
Lordship, there is an execution proceedings going on. Was it 27th of this March of this month?
This fixed on, execution matter is fixed on tomorrow. So we may take some convenient date there.
Then
On 31st, lordship.
Till
31st March.
Yes.